Hi, it's Paul Banis, the GreatDad.com, and thank you very much for joining either the podcast or the YouTube version of the podcast. I'd really appreciate it if you took just a second to subscribe either on your podcast app or in YouTube. It doesn't really do anything. It's not going to send you any emails. It's just going to show up more often on your feed, and it does me a lot of good in terms of getting more exposure for this work I do to support dads. I'd also like to invite you to come to my page, GreatDad.com/go, if you'd like to discuss more about any of the issues that we are covering within the podcast, especially if there's any way I can help you to be a sounding board in your own struggles to be a dad and to be there for your family. So take a look at that. It also includes a link to my course on gratitude, where at GreatDad.com/gratitude with a offer to take that course for free. So see you in a second. Hey, it's Paul Banis with GreatDad.com, and I'm here with my weekly series talking about modern fatherhood. And I've got a gentleman on today, Adam Zuckerman, who is not a dad himself, but I think this is going to be a really important show because of the content relating to legacy planning, estate planning. We're going to get into that and touch on a bunch of things that maybe you need to know today and maybe some things for long term. So welcome, Adam.
Oh, great to be here. Thanks for having me.
I took a look at your website. I was really very interested, and I'm surprised nobody has done a lot of this. I mean, there are certainly other websites that get into the legal contract parts of, and I've used those myself to write up a will and trust, and for especially simple documents like that. But you've developed this site called buriedinwork.com that really takes a deep dive into all the aspects of estate planning, things that people just don't think about, and maybe questions that even wouldn't be asked by an estate planning attorney. So, how long has the website been around?
Actually launched last November after my father passed away. I'm an attorney, I have an MBA, and I went through the process of simplifying the transition for my mom after he passed. And when I showed my mom's financial advisor what I had put together in terms of tracking everything, I used this template on this date to contact this company for this reason. Here are next steps. She told me it was the most comprehensive transition she'd ever seen, and I had to give it away. So we showed a few friends. Next thing I knew, I built a website. In a week, we had over 10,000 visits, and it has grown significantly since then. And the reason why people find it so helpful is exactly what you said. We're aggregating resources to simplify estate planning and end of life tasks in a framework that, quite frankly, most people haven't done before.
Luckily, it's not something that people have a lot of repeated experience with. But I saw that one one quote you had on the website was that the average administration of an estate takes 570 hours. And having gone through that with my own father, I don't even know if that even captures it. I mean, it seemed like just an endless, once you get over the grief, and some parts of it actually kind of maybe help you through the grief because you've got so much damn work to do if you're the executor of the estate. So anything that helps simplify that process, I'm sure, is really appreciated.
That's absolutely right. And the reality is that it is far too complicated to transition estates, and you're oftentimes doing it in times of grief, like you said. And the reality and the reason why is because you go on the scavenger hunt. So if I
Right.
invited you over for dinner and we've got the recipe already picked out, we've got the ingredients on the table, you walk over, there's a bottle of wine on the table, the oven's preheated, we're going to make a really quick, nice dinner. But if you come over to my house and we have to come up with a recipe, we have to search for the food, and we don't know that the steaks are in a freezer in a closet locked downstairs, it's going to be a little bit more
Right.
complicated. And that's really what we're trying to help people understand is that estate planning is far more than just having a will or a trust. There's so many more components to that, from advanced directives to key contact lists to what do you want to have happen to you if something were to happen to you. And that's what we're doing is we're getting all of your information in order, organized. So in the event something happens to you, your loved ones, your wife, your husband, your family, your kids, your friends, they're not put in a position where they have to go on that scavenger hunt and figure things out.
Yeah, I can tell you that it's the top thing is you're planning the funeral and all that stuff, but then even you go all the way down the list. Comes down to like canceling magazine subscriptions and all that stuff. Just takes an amazing amount of time. Now, so one thing I want to capture real quickly before we move on is that you said kids. Is this something that people should think of for I mean, I've got 20 and 24-year-old kids. Should they be thinking of at least writing something down for either practical purposes or for legacy purposes?
Yeah, absolutely. And I'll answer this in two ways. The first is that the inevitability is that everybody passes away. I know that's news for everybody. If you are my mom's age, 75 plus, or you are younger, you are going to pass away eventually. And the goal is to leave things in a position that your loved ones are going to be as impacted in a minor way as possible. So
Right.
simplify. So if you have kids, you should be doing this. If you're married, you should be doing this. But the way that we look at it is the day that you turn 18, that's when your estate planning journey should begin.
Hmm.
And our mantra is create your estate plan today for tomorrow and have it evolve with you over time. So, sure, an 18-year-old probably isn't going to have the need for a revocable or an irrevocable trust. They're not going to have as many assets as someone who's a professional retiring at the end of their career. But that's actually a good thing. They can create a very basic estate plan of this is what I want to have happen to me. And over time, they revisit it 5 years, 10 years, whatnot. And then as they get older, as they have those major life events, they figure it out. And the flip side of that is that because they are your kid, they need to make sure that you are taking care of your assets, that you are taking care of your situation as well. And they should be informed because in the event something were to happen to you, you don't want them to be surprised. Now, what we've found, which is actually somewhat surprising for us, is that sandwich generation, people my age, 45-ish, are taking care of themselves, their family, their children, as well as their parents. And they're actually some of the most frequent visitors to the website for resources because they realize that the responsible thing to
Yeah.
do is get your affairs in order.
Yeah. Yeah. I feel that very intensely. I've got a 95, soon to be 95-year-old mother, who, in the case of my passing, I wouldn't want it to be totally on responsibility of my wife to take care of her. So I have to provide for her in some way. And you have to kind of map that out to make sure in the worst situation, you're not gone and you're old, somebody who's you're taking care of is, left hanging. So in terms of the 18-year-old, I suppose it would be like beneficiaries for a 401k that they might have gotten from a job. It might be leaving the passwords for their Facebook or Instagram account just so somebody could post on there that, a horrible event has occurred. Are there anything other things that an 18-year-old would need to do?
So for anybody, if you have a bank account, if you have a 401k, if you have insurance, anything like that, you always want to make sure that your payable on death beneficiaries are indicated. And the reason why is that it simplifies the probate process because those are contractual arrangements. They
Yep.
don't actually go through probate.
Right.
They actually transcend and get processed before the wishes and the wills do. So that's an easy thing. Your digital legacy, very important. It used to be that if something were to happen to you, the mantra was check the mail. If you don't pay a bill, someone's going to send you a letter and check it for 2 months. You'll know what bills are outstanding. But now, with all the different accounts that we have, with everything going paperless for a variety of different reasons, now you have to have access to your emails. So if you're using Facebook, designate that legacy contact in there that can go in and modify things. Make sure that one or two of your family members have the ability to access your online accounts because your phone and your email are so important to this process. And that's your digital legacy. But you don't have to go to the extent of creating a revocable trust or an irrevocable trust again if you're young, unless you have a significant amount of assets. What you want to do is make sure that you have a very basic will, that you have a very basic advance directive that says what happens to you in the event that you can't advocate for yourself. And from there, then you start expanding the complexity to meet your needs.
Yeah, that is important. I mean, maybe the top one among those is the living will and how you'd want to be taken care of, because that is it's a horrible situation. I'd even go as far as to say it's irresponsible not to have left instructions on those really important questions that nobody wants to deal with, but in the moment would be just horrific for somebody left behind. So getting back to the broader question of this is, I guess, legacy versus estate. I mean, most estate lawyers, you sit down and you may have somewhat of an emotional conversation or more vulnerable conversation, but it's usually just treating the estate, the assets. What do you want to do with the assets? And I think you take a kind of larger, more holistic approach that it goes beyond that. In my coaching with dads and trying to help them understand how the role that they play, we talk about legacy as a value, and many men just do go to that. That's one of the, 4 or 5 values they immediately grab onto, because they feel this weight of, some place in history and passing things on. So I'd like to know how maybe it was with your father's passing that you became more, I don't know, associated or more interested in that whole holistic part of this story.
My father had cancer for 6.5 years. He
Oh
was
yeah.
actually at my house, walked up the stairs and said, "I'm tired." And he went to the hospital. He went back to the doctor. I actually donated bone marrow to him the first time that he got
Mm.
sick, and we got him some extra time. We became very close, both, more emotionally and physically. I could joke that he kept me around for spare parts. So he goes to the doctor. They run some tests. They check him in the hospital on Thursday, and he dies 12 days later. Super quick. And the interesting fact of what happened was he actually had his mental capacity with him literally up until the last day before.
Hmm.
He was sleeping a lot, and palliative hospice care, whatnot, came into play. And what I realized was I did not want to be sitting down and talking to him about the passwords that he had, about where his will was, about who gets what, because that's something that I and the family would end up having to figure out regardless. Instead, we wanted to talk and create lasting memories that we wouldn't have that opportunity to have or create after he's gone. We actually ended up creating a game out of it called One More Story. That's 126 cards, 6 different categories to help ask those specific questions and connect, because that legacy that somebody leaves is so much, I'd argue it's more important than the estate planning aspect, which is just the transfer of your financial, your assets, your
Yeah.
legal, your medical affairs, and your directives. Um, for me personally, I don't think that anybody's going to remember me in 300 years. You have to be a very unique person to do that.
Yeah.
So the legacy that I want to leave is, one, leaving the world a better place than how I found it, and B, leaving messages for loved ones in my life that if something were to happen to me, they understand what they meant to me. And that can be in the form of written, it can be in the form of videos. There's services out there that can help you do that. But bucketing, like you said, the estate plan side of things, which is the legal transfer, versus your
Mhm.
legacy side of things, which is the more emotional, holistic side of things, is extremely important for people to understand.
Yeah. So you on the website you have all these tools, and I think at first glance, because I went in this and I asked you before the show started, that it seemed like everything there was a price for everything, and it was a little bit daunting because I'm not ready to shuck it, throw out $25 for some of the template bundles today when I only need one document. But maybe explain on there how much there's just considering you just did start this a year ago, it's an incredible amount of resources, and they're not just blog articles from the top of your head. They're highly researched uh, articles, and then also documents and templates. So maybe help us understand what is free, or what could people get out of your website immediately without before they jump in and buy some of the bundles.
95% of the content on the website is free and will be free. And the reason why is I don't want people to have to figure out how to do things on their own for the first time in stressful situations and have to pay for it. I just don't think that's right. I don't agree with it. We have over 2,000 articles. We have 100 plus checklist guides that are for free. We have a free estate summary worksheet, which is part of a free bundle in the shop. That is a 3-page worksheet of, do you have a will? Do you have a trust? Who needs to be contacted? And a recap of your financials and other important information. We have a worksheet called Ask 3 Questions, this is free too, which provide details of what questions you should be asking about every single one of your accounts, whether it's financial or insurance or retirement. We have free directories that you can search for every single unclaimed property database, federal and state. We
Hmm.
have free
Oh,
resources of how to shut down and who to contact accounts for 100 of the largest companies in the country. We have free directories that include what makes a will legal in every single state, how to order advanced directives, how to order your death certificates. There's a lot of information that's on the site that is for free that you just have to start digging down for. And it's oftentimes easier to find it on the website because the menus are a little bit different from mobile. So that might have been a thing. That said, we also have a lot of paid products. We've got our Clear Kits, which are called the most comprehensive end-of-life resource available in the country. That helps you have all of your information in one place in the event something were to happen to you. We've got the 2 card games, One More Story, Nothing Left Unsaid, which are a lot of fun. We've got some pretty neat services as well, and 20 service provider directories to help you connect with professionals that can help you move through that process as well. So it's a lot.
Yeah, it is a lot. How would it compare with some of the other products out there, like I think Quicken has a will maker that I've used before.
Yeah. So we don't want to make your will. We don't want to make your trust. Those are great services. There's a lot of different services out there, and we actually refer. Instead, what we want to do is educate. So if you go to the Create a Will hub, for example, it'll say there's 3 ways that you can do it. There's even a free quiz that you can take that will give you a recommendation of what you should do. And there's 3
Hmm.
ways: is by yourself, online, or with an actual legal professional like an attorney. Now, if you want to do it yourself, we'll give you the requirements and maybe a template. If you want to go with a service, we've got links out, and we get a referral fee for those links as well to companies like Quicken or Trust and Will and others, like you
Hmm.
mentioned, Willmaker. And then if you want to have an actual attorney, we've got relationships in place with Legal Shield and also have our own directory. So our goal is, if you come to us and we can't answer or we don't want to answer the question, we're going to send you to a service provider that this is literally all they do. And the reason why is you're unique. If you're listening, you're unique just like everybody else. And there is no one size fits all. Instead, we want to help you organize your information, identify what those gaps are, and then send you on your way so you can get the job done more efficiently.
Right. Okay, great. And then I guess we talked about this a little bit before we started too. Is do you have any resources that help on all the different permutations of families today? I mean, so many people are in partnerships rather than marriages, and I suppose some of those turn into common law relationships, and then they follow the regular rules of marriages. But there are also many, many blended families where you've got a child from a first marriage, and you've got a wife who maybe doesn't even have a relationship with that child from the marriage, and you want to make sure that things go the way you want them to go rather than be turned into a fight afterwards.
Yeah, and that's the difference between having a legally binding transition of your assets versus promises and the complexities that go in between. So typically, the way it works is a promise is very nice, but it's not necessarily going to be enforced or honored if a court were to step in. Now, wills are oftentimes more legally binding, trusts are legally binding, and the blended family relationships complicates all of this. And what we say is that if you have a very simple estate, those DIY scenarios can
Yeah.
be very good for you. But the second you have multiple marriages, multiple kids, multiple assets, that's when you typically want to engage a service provider that is not only a professional, but also a professional in the jurisdictions where you specifically live, to make sure that you aren't going to run into a case where your estranged cousin that you once said, I promised this to, is going to file a case based on promissory estoppel, saying that they relied on
Right.
your promise to their detriment to then overturn what you've asked to do in your will. So there's a lot of complexities there.
Yeah, and I from personal experience as well, I would really encourage people, if you start writing these documents, if you write them on your own, or even if you use an estate lawyer, that you are very, very clear on what the legal language means, because some things to a layperson that seem just totally direct, like in the case of need, you will provide resources to your stepmother, which is something that actually happened to me. That in the state of Virginia does not mean you might or you could. It means the trust is locked up until she is gone, and you have that responsibility unless you have a life-threatening disease of your own or some other emergency. You may be reading that document incorrectly.
Yeah, and that's what's so important, is that these are legal contracts oftentimes, and legal contracts oftentimes uh, assert and have meaning into specific phrases that just might not be something that you're typically accustomed
Yeah.
to. So as you start drafting your documents, what you should do is simple. You can take care of it yourself if you need to. But the second that there are multiple people involved, that there are multiple assets, complexities, involve somebody that can help you because they're trained in that specific field. And the way that you can actually reduce your costs and reduce your time there is get all of your intents organized before you go and see those individuals, because
Yeah.
they oftentimes charge you by the hour, up to
Right.
400 plus per hour. And when you go and say, this is what my intent, it's written down, here's this, they're going to be able to serve you better and more efficiently because they don't have to ask you the questions that you've already answered.
Yeah. Yeah. There are other resources that can get to some of those questions before you get to the lawyer. I mean, if you're working with a financial planner, for example, sometimes they will have in-house resources that will have thought through a lot of that and can draft maybe they can do a first draft, or at least they can provide you with some of the things that you need to immediately talk about with an estate attorney.
And that's a really good point. So oftentimes people say, I have an estate attorney, they're going to handle my will. But then they also may have a CPA or a tax attorney or a financial planner. What's really important, though, is for those service professionals that you're working with to know that you are working with other service professionals, because your trust that you set up might not know about your financial tax harvesting, initiatives over here. So you want to make sure that everybody knows everything so you have the best situation outcome for you and your family that you want, because the last thing you want is for them to find surprises later on down the road that you didn't know about.
Yeah. And what level of assets would you need to be concerned with to start thinking about tax avoidance, estate tax? I mean, now I guess the estate tax is elevated to such a high degree that maybe it's immaterial, at least for the coming time. But is there a point where that becomes a level of assets where that becomes more necessary?
Yeah, it depends. So in 2024, the federal estate tax exemption is $13.61 million
Oh
per
yeah, yeah. Well,
individual. So
nothing
unless
to
you
worry
are
about.
very well off, and that doubles also if you're married. So it's
Okay.
27.22 million. Unless you have a significant amount of assets, you don't have to worry about the estate tax exemption itself. There also is some states that have inheritance tax. But rather, what I would say is the moment that you have $750,000 or more in total assets, you should be engaging with a service professional that can help you. Because if you're spending $2,000 to have initial, and I'm just benchmarking, $2,000 for an initial consult and some documents to make sure that that money is transferred the way it should, it'll save everybody a lot of time and a lot of hassle.
Yeah. And very important to realize, even though Uncle Jack is offering his services for free in Wisconsin and you live in California, not a good idea.
Not a good idea. No.
Yeah.
Uncle Jack is a great guy. He's fantastic for you to recommend your friends go and speak with. But when it comes to matters of this, you want to eliminate the possibility of anybody claiming that there was impropriety, that there was any, mixed feelings, anyone that was asserting undue influence in places that they shouldn't be. And Uncle Jack, while he can be your executor, fantastic, he shouldn't be the one that's setting everything up.
I guess I was getting to the point. That's a very good point, but I was getting to the point of the fact that the state laws differ from place to place, and what Uncle Jack might be saying would be wrong. And if he is advocating to do the legal work, he's probably not a very good lawyer.
Very much so.
So, when you're talking with your kids, I mean, I think especially if your kids are younger, this is a very hard conversation for them to have because they can't imagine a time when you're no longer there. Are there ways that people can? I guess your game is one way that some of these conversations can come up. But I was just thinking, like, if I had the conversation with my son who's 20, and I said, if I were to get hit by a bus tomorrow, not a long-term illness or something horrible, that would be like that, but what things would you need to know? Things would you want to know? What things would you like to have? Do people have those kind of conversations?
Yeah. So what we recommend is there are levels of conversations that you should be having. And as you age in life and as your children get older, you can shift what that tenor of that conversation is. And having early conversations actually makes those later conversations much easier. If your children are 18 years or younger, you should not be saying, in my will, you are going to get this, this, and this. In the event something were to happen to me, and I'm on a breathing tube and I can't advocate for myself, I want you to do this, 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 and this. Absolutely not. Don't do that.
Not fair.
Instead, what you say is, hey, I want to let you know that I care about you, that I love you, and I don't want anything stressful to happen to you, or I'm going to do whatever I can to mitigate that if possible. In the event something were to happen to me, I've put things in place that I will be taken care of and you will be taken care of. This is who you need to go and speak with in the event something were to happen to me, and you let the adults in the relationship handle it. And then as they get older, you say, I have a will, I have a trust. Here's where you can find that information. Here is the attorney that put it together for me. Here are
Yeah.
where my advance directives are, and this is what they are. And then as you get older and they become 30, they become 40, and you're in your 60s or 70s, whatnot, then you can start talking about, I want to be cremated. I don't want to be cremated. I want this to happen at my funeral. I want this not to happen at my funeral. And as they get older, as you get older, you start evolving those conversations. But the thing is that is important is that you have to start having those conversations. And it's hard.
Yeah.
It's hard.
Yeah. And related to that, how many, do you know how many states have community property?
I'd have to go and check.
Well, definitely California, but there was one aspect of this that we've discussed and is a warning for everybody out there is that community property, the way it works in California, is any assets that you acquire after you become married, become community property, and they're 50-50, and that's all well and good. That's kind of expected. But what a lot of people don't realize is that if you have an estate that is left to you personally, or a trust that you are the beneficiary of, the minute you mix those assets with another person, your spouse, that also becomes community property. So if you've left them $100,000 and now you spend one nickel together as a family from that, it becomes community property. And that's important to realize because you may be leaving money to your child who is relatively young and may get married to somebody after you've passed away and they have this money that was meant for them. You don't know who that other person is, and you may want to safeguard that money.
Yeah, that's right. And it's important to understand the nuances of the state that you live in. It's less than a dozen states that have community property. And the reason why I don't want to give the number is there's some strange situations like in Alaska, you can opt into community property, I
Oh yeah,
believe, if you want. Um, but it's important for you to understand, and that's why I say go to a service provider professional in your area that is familiar with your situation. And when I say familiar with your situation, someone that has $500,000 or less in assets is someone that is very different from what's considered an ultra high net worth individual with millions of dollars. And the attorneys that you are working with, you want to make sure that they are used to working with people in your specific economic situation or family situation. And what I mean by family situation is that blended nature of potential families, because that really does matter. Now,
yeah,
if you want to have that conversation with your parents or your children and you don't know how to figure that out, we have a free quiz on the website. There's a section in our info hub, Start the Conversation, and you can take that quiz and it'll give you a score of 1 to 10, how organized your estate is or someone else's estate like your parents. And then based on that score, there's little cut and paste tidbits of, hey, mom, dad, I took this quiz, I scored this, and I'd like to talk to you about XYZ because, and then you're blaming it on us for having the conversation, which you can do anytime you want, blame it on Buried in Work, to start that conversation as opposed to, hey, I'm just doing this on my own.
yeah. Okay, that's very good. And I guess a question that jumps in my mind immediately is trust versus will.
Mhm.
Which one is the dominant document? I assume that even if you left the house in the will, but it's shared in the trust takes precedence.
Trust and wills are related in a legal way in the sense that they both help transition property after someone passes away. And the key distinctions of what most people need to know is that it's a level of speed and privacy.
Right.
So wills are filed with the state in the local jurisdiction where you live. So literally, if you have a doll collection and it's in your will, that will is going to be filed. Everybody's going to know that you have that doll
Yeah.
collection, right?
Yeah.
And you want it to go to so and so.
Right.
A trust, though, because it's a contractual relationship and an entity in its own right, that does not get filed with the state. So if you want to avoid probate, if you want things to be a little bit faster, then a trust is warranted. Now, there are dozens of different types of trusts that are used for different reasons. We actually have a free guide on the website, Introduction to Wills and Trust, that you can read to learn about them. But I implore you, if you are going to have a trust, do not set it up on your own. This is me with my legal hat on. They are very complicated. They can have unintended consequences that you don't
Yep.
know. But
Yep.
if you have privacy concerns, if you have speed concerns, if you have a significant level of assets, a trust might be good for you. The other thing that's important to note is that you can have them linked. So there's something called a pour over will, for example, which means that your will effectively says that anything that I own at the time I pass automatically will go into my trust. So it's not there while you're living. So that's the type of thing that you need to be talking to an attorney about.
Yeah, that's really good advice. I also wonder whether if you have assets that are relatively minor in financial importance, let's say you have a coin collection worth $1,000,
Mhm.
putting that in a will requires time, legal time to put in. Is there a value of things like it's better just to say if you trust the people around you, I guess I want this vase to go to, Jerry or whatever, rather than writing out up everything as a specific item.
Yeah, it's a great question. So the thing is, a lot of people are afraid of probate, and probate isn't bad. By
Yeah.
default, it's not bad. It's just can be timely. But there's different types of probate where you are. So if you have less than $50,000 in certain jurisdictions, you can have an accelerated or a simplified probate process. So going through and listing out, this is specifically what I want. I want it to go to this person. It's not so much the complexity of taking the time to write it out. It's not so much the complexity of what probate might do to it. It's not the
Hmm.
complexity of would it be simpler if it were in a trust, but rather it's the totality of your unique situation that you have to understand. Now, you can go either way. You can have a will that says, I want this specific thing to go to this specific person. That makes it very, very easy, but it's still going to have to go through that probate process. And
Yeah.
you're still going to have an executor, and they're still going to have to file, and the creditors are still going to have their opportunity to come back and tag back against the
Yeah.
estate. But that's just what the process is.
Yeah.
And the question is, how efficient do you want that process to be, and how easy do you want that process to be on your loved ones?
Yeah. And the creditors can go after the trust and the estate. Yeah, but you can't protect your assets in some ways from the creditors, which is probably a good thing. Okay. Is there anything else that I haven't covered here that's important? I think probably the conversation, if people have hung on this long, is that without getting like totally burnt out, is that it's a very complicated process, and until it happens to you, you either don't want to think about it or you don't know about it, so you kind of keep on putting it off. But it wouldn't be a bad idea just to dive into your website today at buriedinwork.com just to get an idea of all the things you might be, just to get the process rolling.
Yeah, there's a free roadmap on the website that you can use. It'll say step one, do this, step two, do this. It'll walk you through a lot of things that you might not think about. What happens to your pets in the event you passed
Mm.
away or something were to happen to you? Who's going to do X, Y, Z? Um, the reality is that every single day in America, 10 to 12,000 Americans are turning 65. The reality is that by the end of the decade, there's going to be twice as many people 65 and older than there are today. And the reality is that women in marriages are outliving their male husbands by 5.8 years on average, which
Mm.
means that if you're in one of those traditional family value households with a division of responsibilities, not right or wrong, it's just the way that things are, where one partner might not be in charge of the finances, that means that they could find themselves in a situation where they don't know how to pay the bills, not because they can't,
Yeah.
just
Yeah.
because they haven't done it before. And it is unbelievably important for us to take the responsibility that if something were to happen to us, our loved ones, whether they be our spouses, our kids, our friends, our family, aren't in a situation where they're scrambling. And that's what
Yeah.
Buried in Work is here to do. So we've got our clear kits, we've got our games, we've got 100+ checklists that I mentioned, guides. We've got literally guides down to the level of if you are Hindu or Jewish or Muslim or Christian or even LGBTQ plus or secular, here's what happens at funerals
Yeah.
and here's how you plan them. So come to the website. If you've got questions, you can't find something, send us a note and somebody on the team will get back to you.
Yeah, I appreciate that. The fact that you cover a lot of different scenarios and a lot of different uh, family types within the website.
Yeah. It's
Yeah.
important. It's important.
Yeah. Very good. Okay. Well, let's see. I don't think I've got anything else on this, though. I'm probably very much enjoying all the free advice because it is so daunting if it does occur to you. Yeah. Okay. Anything else you want to? It's buriedinwork.com. I'm talking to Adam Zuckerman. Anything else that you want to direct people to directly?
No, I think that come to the website, keep going to GreatDad.com.
Thank you.
Fantastic site. Yeah. We're here to help out. And if you have any questions, please do drop us a line. I'd appreciate it.
Okay, great. Paul Banis of GreatDad.com. Thanks again for listening. You can check out my coaching resources, some of which does touch on legacy at greatdad.com/go. So until next time, stay strong.